Hello, good morning. Can see we've got a couple of people here already. That's excellent. I'll make it 3 minutes to 9. We'll be starting in a few minutes. Hopefully a few more people will have joined as well by then. Let's have a look. Hi, good morning, everyone. Couple of minutes now, and we'll get started. Hi, good morning, everyone. I'm just going to ask someone. One of the things that frustrates me about Teams, and I also need to learn a little bit more about it, is that when I set up a meeting like this, I've set the preferences for everybody just to be able to be admitted without having to wait in this lobby thing for someone to click that it's okay for them to come in. So I can see that it's Deborah Bradwell, and I've just got this thing coming up saying view the lobby. Can you guys, or can someone else, can you guys see that as well? I suspect you can, because what I'm going to ask is, can you admit people for me? Because one of the problems that I get when I start doing the presentation, I don't get to see any of this anymore. And so I sometimes people will come up if they join late and it says waiting to be admitted in the lobby. And I don't, as I'm presenting, I don't see that. So if any of you see that message come up, please just click yes to admit them to the meeting, if you wouldn't mind. That'd be great. It's a frustration. I'm obviously doing something wrong because when I set the meeting up, I always put that people can bypass the lobby. I always set that as an option so they don't get stuck and have to wait for to be admitted. But I must be doing something wrong because I've had it before where it doesn't seem to have accepted that, and it appears this morning that I'm still getting those messages up saying that people have to be admitted. And like I say, the problem is that I don't see them when I actually start doing the presentation. Right. A little bit of admin. Okay, it's a couple minutes past my. I'm never quite sure if this is a good time to do things or not. I did have some feedback from practice managers previously that it was a good time to do it first thing in the morning before you got dragged off doing all the other millions of jobs that you guys have got to do. Yeah, when I do these ones that say like a 9 o'clock start, the attendance never seems to be that brilliant, if I'm honest. Anyway, and thanks to you guys who have pitched up this morning. That's great. It'll be recorded anyway, so I'll put this on our YouTube channel and I'll send that out so everyone will be able to see it if they want to. Okay. Excellent. Right. So I am going to make a start in a moment. Once I can just sort out my settings here. That's great. Let me share my screen and get this presentation going. It's going to be that one. And I'm going to do. Okay. Hopefully everyone can see that, which is basically the opening slide. Okay. Can I just ask one person to come off mute quickly and just confirm to me that you can see that and that you can hear me okay, and then I'll make a start. I would hate to be babbling on doing all this stuff and then actually find out that no one can actually hear me anyway.
Yeah, we can hear you, Barry. We can see it.
Lovely. Thank you so much. That's fantastic.
Right.
Okay, so let's go. Oh, and I've got a message saying people are waiting in the lobby. Brilliant, and I can see that's disappeared, so someone's letting them in. Thank you for doing that. That's great. Okay, let's get going. Again, I appreciate your time, ladies and gents. I know how busy you guys are. I will record this as well if you feel you missed anything. If ever you have to go off and do other stuff, I'll put it onto our YouTube channel. In the conversation bit of the Teams meeting, I put at the top the link to the IG web portal. Again, this will be on there later on, but that's, I think I referred to it a couple of times, that there's loads of stuff on there and we're updating it every week or so. So if you get a chance to have a look on there, a lot of the stuff I'll talk about today will be on there already. So, and I will mention it a couple of times, but that link is in the conversation chat now. So let's quickly run through what we're going to talk about today. It'll be fairly brief. There's only 4 or 5 topics, I think. Go look at very briefly the Data Security Protection Toolkit, just confirming the new dates for you, which I think you've already seen anyway. I think I've put that out. We'll talk about incident reporting. I was actually going to do a live one online, but very frustratingly, the data security system is down this morning for some sort of renovation, so that'll have to wait. But we'll talk about it. But the actual demo will have to wait till next time. Going to briefly talk about patient registration and some of the issues around that, because that's quite a big topic at the moment. Online access as well. I'll talk about some work that we're doing around that to help clarify things for you guys. Very briefly, subject access requests, and then a word on CDs and USBs. Okay, and that should all take about 20 minutes or so, I think. And if you want to jump in and ask questions as we go along, please feel free. But maybe easier if you just leave questions till the end or write them into the chat. When I finish the presentation, I'll go back and review anything that's in there. So you'll know that this Security Protection Toolkit is formerly what we used to call the IG Toolkit. Annual submission. The deadline for the next submission is June 2022. And you know you've just done one in June, just gone past in 2021. That was the delayed one. Obviously because of the pandemic around March the year before. So what's been decided is that on an ongoing basis, it will be due every year at the end of June. So basically the whole system has moved from always being required at the end of March on an annual basis. It's now going to be every year now, it'll be due at the end of June. I know that there's lots of pros and cons about moving it from the end of March. That's a busy time for lots of other returns and things that people have to do. So a lot of people think it was great. A lot of people aren't very happy about it. I think some of the big hospital trusts and so on that have audit schedules and stuff planned for years ahead have kicked up a fuss, but that's what it's going to be now. So end of June, and pretty much don't worry about trying to remember it, because I'll be reminding you, you can be sure of that. And obviously nearer the actual time itself, the technical data that you need will be on our IG portal. Okay, reporting. As I said, I was going to run a live one, but we can't do that. So we'll just talk it through. So any information governance issue, anything that involves personal data, it could be classed as a data issue involving someone's personal information, must be reported, and they must be reported to a number of people and places, essentially. First one would be your data protection officer. That's me, guys. So please let me know. And that one, I could say, report to me. Even if you're not, it's like a formal report, just let me know if something's happened, and then we'll have a chat and say, okay, this does need to be formally reported. But please, I've seen a couple of incidents that have gone through. In one case where I was kind of told of the outcome and I hadn't even been told of the incident. You know, this is a two-way thing. I'm your data protection officer. I'm absolutely here for you guys to come and ask me any questions, anything at all, and I'll try and give you as much information as I can and provide you with advice and assistance and all that sort of good stuff. But I do need you to be telling me of actual incidents as well that happen. And that first bit doesn't have to be a formal notification to me. You can just ring me up, drop me an email, say, can you kind of let me know, have a chat about something, and we'll do that. But please keep me in touch with what's going on. So the ICO now requires that everybody, all organizations, report incidents to them. So it used to be previously public sector were very good at reporting incidents, and other companies weren't. GDPR came in, requirement that everybody reports data incidents to the Information Commissioner's Office. I think they were getting a bit overwhelmed by it all, so they've kind of tried to filter it a bit. And one of the filters that they put in place essentially is across healthcare. They've said that any organization that essentially uses the data security and protection toolkit, so anyone who's got access to it, must report their incidents through the toolkit. So it's a way of ensuring that all the ones from healthcare come in to the ICO in one specific way. So you're actually not, well, you're not allowed to use their direct reporting, but you shouldn't. The way you should do it is to put it through the toolkit. And one of the things that actually does, and what I was hoping to be able to demo to you, is that as you put in an incident, it will ask you a number of questions. So the first couple of questions will be what happened and what did you do and that type of thing, which is a bit of a narrative. And then there's a number of questions that are very specific answers. How many people were affected? Have you told the individual? Some that are specific numbers and some that are specific yes, no answers. And based on your answer to those, the system will decide whether your incident needs to be reported on to the Information Commissioner's Office, or whether it stays as a local incident to yourselves. And obviously, if it does stay local, then you put it into your own system so that the security toolkit becomes your local management system. And it's only when you've answered all those questions and pressed enter at the end, if it needs to be submitted, it will submit it. And if it doesn't, you'll get a message coming back saying it doesn't. And what I can say, we can't quite second guess all these things, but certainly an individual case, which is probably the most common one, where perhaps you send a letter to the wrong address or an email which has one patient data going to the wrong person, essentially. As long as there's no connection between those, you haven't sent it to a different family member or someone like that, then in most cases they won't be reportable incidents. But you've reported them essentially within the system, but they're not reportable to the ICO. So you've got a record of them in your local system. So that type of stuff won't go onto the ICO and won't trigger them and come to investigate you or anything like that. But as I say, it's a shame I can't do that, but we'll look at doing this next time. But the main thing is you must be getting these reports in and putting them onto your system. Obviously, reporting to a local management, to your CSIRO, if you're working within the practice. Senior partners need to be aware of an incident. And so I've just said the system does this data assessment as to whether it needs to be reportable to the ICO, because essentially, so GDPR requires that all incidents are reported, but that the ICO simply cannot cope with every single organization in the whole country, including not all your companies and everything reporting every single little data loss. So there has to be a level of filtering, which is what for organizations that use the data security protection toolkit, that's why you put your incidents through there and it does that filtering for you. And GDPR requires that we report data breaches within 72 hours. Don't get too tied up on that. You can see if something happens on a Friday night, it may not be till beginning of the next week, but it's just get the idea that it needs to be done fairly quickly. Don't sit on these things and we'll report it at the end once we've investigated all the stuff like that. Get even the basic facts in initially fairly quickly so that you can cover off that requirement. Okay, patient registration. I think I've spoken about this before. There's been a number of issues. One very significant issue where a couple of patients, due to an error that was made in the report in the registration process, became mixed up. Records were merged, and it wasn't noticed. Now, these things happen. I know that, and the work we've done has suggested to us that they happen more than we possibly even thought. Most of the time, 99%, whatever, they're resolved very quickly without any issues occurring. But they are still quite resource intensive to resolve. In this significant case, it wasn't noticed for 4 years, and those cancer treatments and all sorts of stuff that were missed and caused problems. And then to untangle 2 records is incredible, very difficult thing to do. So it is an issue, and clearly what we want to eliminate it totally, but we certainly be on the basis of what's happened in a serious issue. We need to kind of ensure that these things don't happen again if we can. So at the point, the issues are around the point of practice registration, and what we're saying, I think that the message would be at the moment, well, that's a fairly reasonable thing to say to people, to be sure. I'd like to take that to slightly, put the bar a bit higher, and I would say you must be absolutely certain. And if you can get that message across to staff, I'm sure now that they're doing that first bit, they'll be, yeah, I'm sure that we've got this right. I'm sure this is the person who they say they are and stuff like that. Ask them just to be, okay, absolutely certain, because the implications of getting it wrong are so significant, as has been seen. We really must be at that level of being certain of the registration when we're doing this stuff. And the same applies when you're merging records. Again, we've seen a number of issues when we've been looking at this now, where practices have merged records. And I have to say, some of the ones that have happened in other areas, in our area, there have been a couple of incidents that have been caused by errors at practices here, but some of the errors that have happened at other practices, particularly in London, where I understand they have issues around staff retention and turnover in some of these big practices in central London, but some of the things that they're doing, literally changing names to make it fit, it's just absolutely horrendous. But obviously all we can do is ensure that we do our bit right. But merging records and that initial registration, please try to be as certain as you can about who you're dealing with, and asking staff just to take that extra bit of care. And I know that you're incredibly busy, lots of other pressures going on, but this is really important. There's a question about asking for proof of identity. The system says you don't need to. So the system put out by NHS England, the processes they describe around registering a patient, says that you don't need to ask for proof of identity. It says something about taking reasonable steps. Now, I know many practices have actually said, well, we'll have a local process that says we want our staff to check someone's identity. And I think that's reasonable. I think that's entirely reasonable. There's a lot of discussion around this, what you can and can't do, but I think it's entirely reasonable to ensure that the sort of issues that we've talked about that we know can happen, to ensure that they don't, because as the data controller, there's a legal onus on you to keep accurate records. And so to do that, it's entirely reasonable, in my view, to ask for someone's identity, to something that shows who they are, and don't just go on what the person they say that they're saying they are. Now, very few people, minute numbers will be trying to register to essentially fraud the system, to get stuff they're not entitled to. That's almost a separate issue. I think this is simply about ensuring that that the person who's in front of you, who's saying, I'm so and so, I've just moved to the area, I want to register the GP, that you know who they are. So when you look them up on the system, you're absolutely certain who that person is. Okay, as we know, names, date of birth can all be the same. You need something that ensures that you've got the right person there. And the final bit, and the reason for NHS England being clear that you can't require proof of identity, because you will always still have someone who possibly doesn't have anything, and then you've got to take some reasonable steps to what do you do if someone has no identity? I suspect it won't get very far in our society at the moment. So there's always something you can get. And it talks about reasonable steps, as I say, but none of that should be a barrier to treatment or care. And clearly that is absolutely the case. But I still think there are reasonable things that you can do without, without crossing that threshold, without making it difficult, without sending people away who clearly need treatment. That must never happen. But at the same time, we can put in reasonable requirements to be absolutely certain that we know who people are when they're being registered. Okay, I'll not labour that point. I think I've gone over it enough, but hopefully you get the message. It might be worth at some point having a discussion with your staff who are involved in this registration, and just reminding them. As I say, people inherently, I know people know what they're doing here, but every now and then just a reminder of the things that can go wrong and the reasons why we need to be as clear as we can around this registration issue. Okay, online access. This is causing a lot of angst for many people. I know that, I'm very aware of it. What I am doing this week is actually starting a whole piece of work around this. I've got a chap joining me, joining our team here at N3i this week, who's come straight from Hull University. He's on a placement with us for a couple of months, and we're going to get him to specifically look at this. So he's a law graduate who's just doing an internship with us for a couple of months, and I'm going to ask him to look at some of the specifics around the relationship essentially between patient online access and what the Data Protection Act says around subject access requests, because there's a tension there about, surely if we're going to give someone a subject access request, why don't we just give them online access? And then they essentially you've got an ongoing open subject access request available to you. And I suspect that's almost where we're going. We need to be clear about things. And obviously the two areas we need to be clear about are the information that can be redacted on a subject access request. So let me quickly run through this. So yeah, there's a requirement on you that you must offer patient online access. It can be either through the system app or the NHS app. What I would say, I mean, I'm registered as a practice that use System One, so I've got the System One app on my smartphone. I've also got the NHS app on there. It does sometimes surprise me when we're talking about this, and I'll say to people, well, this is what you see, that more people don't have this available to you. I'm not asking you to put your hands up if you've got this or not, but I would suggest that just so you know what it looks like from the patient's perspective, I think it would be a good idea, even if you don't feel you're going to use it yourselves, if you set yourselves up with the system app and the NHS app. I mean, I think from patient perspective, for things like repeat prescriptions and appointments and so on, it's a no-brainer really. But to be able then to see in terms of the system and looking at the record itself, it's quite interesting to be able to see it from the patient's perspective. So when you're dealing with them, you'd have a better concept of what they're seeing, and they are quite different in the two different systems there.
Barry, can I just ask you a question?
Yes, please.
On ours, when people want online access, some people say they want it constant. We only actually give it for 24 hours. We say you can have 24-hour online to get off whatever record you want to look at. Are we wrong for that?
I don't think right or wrong. I don't think there's a right or wrong on any of this. I just wonder what that achieves, because I suspect the person will just come back in the future. The tension you've got here, and I appreciate, is this between the redacted information and that and the patient being able to see it. So if you've got someone who has essentially online access available all the time, as I said, they've got a kind of like a real-time subject access request going on.
Yeah.
Which, as long as you're then filtering the information in terms of the redacted information in real time as well, then that's fine.
Okay. Right. Okay. Thank you.
I think.
Yeah. Thank you.
Okay. Like I said at the beginning, I've got this chap joining us, and this is going to be his project, if you like, to work through these things. And I've made a note of that very point there, because they're the sort of questions I'm going to look to get, and I'll get him to we'll be doing a webinar around this in a couple of weeks once he gets settled in, and they're the sort of questions I'm going to ask him to look at. How exactly do we do we operate these online services, which you're being required to do and being encouraged, and patients are being encouraged to take them up? How do they fit with those sort of legal things and the data stuff? So that's all that we're going to cover off. At the moment, I think we know the principles, but it's difficult to match them because there are some bits, it almost seems that they're confused, well, certainly confusing, but that they don't fit together very well. And I'm going to try and work out a way. I'll try and get some clearer guidance for you about how this all works. Because this is sort of stuff, I mean, you know, I've still got it on here. The two bits that are the data exemptions, the only thing I would say about these, and I've talked about them before, is keep them in perspective. Third-party information, it's probably fairly unlikely that many of your records will have a lot of third-party information. That's people who where the patient doesn't know who they are, where someone has put in information, whether that be I mean, examples, possibly a neighbor who may have added something to it, perhaps a relative, something like that, who the patient wouldn't know. I think we need to be a bit clearer about how that works and how, and you can flag that in the clinical system so it doesn't display. The serious harm test I've talked about before, and I do think from some of the examples I've seen that sometimes gets overused. If you go onto the web portal that I talked about earlier, there's a fact sheet on the serious harm test, and it is a very, very serious, you know, it's a very, very high bar to meet, if you like. I would suspect that very few of you will have data that would pass the test if it was properly applied, the serious harm test. And I do think it's sometimes overused. So actually those two data exemptions, you're not going to see all that many of them. So I think it's keeping that in perspective, but obviously bearing in mind that we do need to deal with them as we go through it as well. But there is a potential here to reduce the number of subject access requests, because if you think what most people actually want when they're asking for it, it's just their record. You know, they may have had some treatment, they may have had various things going on over a period of time, let's say the last year, the last 2 years, and they just want that documented. They want to be able to see, oh yeah, that I went there, I've forgotten about that bit, I remember I went there and I had this here, and if they can see that, that's perhaps all they want. So if they get online access, then they've got it. They don't need to make the whole request to you. It's a potential. I'm not going to put it any more than that, but it could be something. So, but I think we do need to understand how these things all fit together. And as I say, that's the work that I'm going to be starting this week. It doesn't help you right now. It doesn't answer your questions right now. I know that, but it is something that we are looking at, because I understand that there are lots of issues around it. I had some more bits about subject request. Yeah, a bit more about the serious harm test here again, just to reinforce, really, have a look at that fact sheet and ensure that if you are redacting data on the basis of the serious harm test, that you fully understood what the requirement is for redacting that data. I noted, yeah, this came up the other day when I was talking to someone. You only apply the exemptions, third party and serious harm, to subject access requests. If you get a request from, say, the police for information, or a court order that says release this record, then the exemptions don't apply. You release the full record. For the police wouldn't generally want the full record, but they might want something specific, and it may be, certainly in relation to, say, third party information, that's the actual information that they need for their investigation. So as long as they've made their case in terms of police having access, and you've got the court order that says, you know, and you're clear that it's a court order, then you don't apply the exemptions to those to that data when you give it out. But what I would also say, and we talked about this in the case I was discussing the other day, which was a court order, it's quite right, if you do look through the record, and I suspect you should do that anyway, if there's something in there you think, well, this is really sensitive, and it was a court order, well, there was something that was really sensitive, we discussed whether it could be redacted, and so, well, the redaction doesn't apply. However, it's quite right when you give the information to the court that you either have a discussion with them, or that you put something on the record or go with it to say there is some very serious information here, it's very sensitive, you need to be aware of it. So to make the court aware, because when you put information that's put as evidence in front of a court, then that becomes public knowledge. That becomes in the public domain, and you'll have people who sit in open court who just can be invited in, members of the public. You can go and sit in a court if you want to, and they'll have court reporters who will sit in and will report on anything that gets spoken about. And anything that happens in a court is classed as being in the public domain. So if you're giving a record that goes to a court, it's quite right to say this, this has sensitive information in, and you may want to treat it in a certain way. And courts will do that. I've seen that happen. A judge will take account of that and will then probably not release that as evidence to the court, but may look at a certain part of it and treat it differently in terms of the way that you've highlighted it to him. We all know this, I'm sure. You can't have a subject access request for a deceased person. That's into a whole different thing. And again, access to deceased records, we've done quite a bit of work on. You can require the identification of the requester. And also, when we're doing things now at a distance, if you receive an email for a request and so on, it's on you how you identify it. The requirement, the law doesn't say you have to see a driving license or a passport. It has to be in person, all that sort of stuff. The law just says you need to be absolutely certain that you're giving out the information to the person who's asked for it, or and often in some cases that the solicitor has the consent of the person to act on their behalf in terms of that identification. But you've got to be clear who you're sending the data to. It's sent out securely. It's still your responsibility to look after it until the point at which essentially it's handed over to the requester. I'd also suggest that if you download it from a data file from your system into a PDF file, for example, send it via NHS Mail using the new secure system. You'll get receipts and all that sort of stuff, even sending it to a non-secure account. Obviously, it saves you having to print it out and stuff like that. But that's your choice. If you want to print it out, you can print it out. If you want to require the person to come in and sign for it or whatever, however you want to do it, that's your choice. You're responsible for ensuring that you have the identification of the requester and that it gets securely delivered to them. But as I say, if you require them to come in and do an ID check at the time, that is down to you. And you can't charge, and everyone's going to shout at me, but I'm sure that I read something last week. So what you did read last week, if any of you noticed it, is that the government have put out a consultation on GDPR and how data protection is working across the UK. It's one of the sort of post-Brexit reviews that they're carrying out. And one of the things that was put in there is about reintroducing the concept of a fee-based system for subject access requests. And I can hear you all cheering in the background there. It's not guaranteed that that will come in. As it's a government consultation. There are a number of changes proposed to the way data protection is currently done. Things such as you wouldn't need a data protection officer. You wouldn't have to do data protection impact assessments. A number of things which in general are aimed to, as the government said, I think, to reduce the burden that many people see data protection puts on all information. And remember, this is across the whole thing. If you want my view, yes, and I know it's my job, but I don't think I'd want to see it reduced too much across healthcare. I think we look after people's information very well, and I'd want to see us to continue doing that and be rightly recognised across the country. GP practices, recognised as being very safe, secure, very trustworthy, and I think any reduction in the way we look after people's information could potentially impact on that. But anyway. So yes, there is a consultation out from government at the moment, which could potentially reintroduce a charge, but it's not guaranteed yet, and certainly there'll be a lot more discussion on it before it actually changes. Interesting. One of the practices out there are having some issues at the moment, whereby there was an incident happened in their car park. And their car park is one of the new buildings, is covered by a CCTV system that they operate. And one of the individuals who's involved in the incident has asked for the CCTV images that show him and the incident that happened. So he's asked under a subject access request, which is what he is entitled to do. So we have to now work through, and it's just really, I put it on there, and obviously there's a process to do that. We have to work through this. Downloading, first of all, how can you download the images from the system? These are sort of questions you need to perhaps think about. If you've got that request today, if someone comes in and said, I had an incident in the car park last week, or in the reception area or anywhere where you're covered by your CCTV system, and the person says, I'd like to see those, the images that you have on me, which is my personal data. So, could you get it off the system? Would you need to go to your system supplier? Do you have a contract? Would you have to pay for that? How do you deal with the other people who will be no doubt caught on that CCTV? What you actually have to do is to pixelate out. I mean, I'm sure you've seen these pictures of people, even if it's a video of someone walking down a street, you have to pixelate out everybody else because you can't identify anyone else in that data. It's the same as giving them someone else's data from a medical request. So that's something that you perhaps need to think about. And then telephone calls as well. I know you're doing a whole lot of stuff over telephones at the moment. Most modern phone systems that you have will record all of your telephone calls. Are you set up if someone comes and asks for you for the details of the phone calls that they had with the receptionist last week? Well, you want to be a bit more specific than that, but someone could realistically come to you and say, last Tuesday, 3:15, I rang and I had a long 20-minute conversation with the reception person, and then perhaps they were put through to perhaps to a nurse who had a further 10-minute conversation with them. I'd like to have a transcript of that information, or I'd like to have the file, the actual conversation itself on a sound file. Is your system set up to do that? Could you deal with it? Just a thought. And you're all thinking, God, I hope that never happens to me. It has happened. As I say, I've got a practice at the moment who have had the CCTV one about an incident in the car park, and they're having to work through these very questions. So just have a think through those. Okay, this is very quick and easy. I know there are examples of people out there. I've got my engineers, my spies out and about who come back and tell me this practice is still using CDs. And then you get a very disapproving email from me asking you why. Please, guys, we shouldn't be using CDs at all. They're a major security risk. They have been for many years. There's no reason that I can see why you would need to send data on a CD. I'd also say you don't need to receive it. If you receive one from someone from a practice, do what you like with it. I mean, destroy it, send it back, whatever, but don't keep it in the system because they're not going to be any use. If you do need to send data, subject access requests and so on, you've got this NHS Mail now, which has this egress system, large file system. It can handle up to 5 gigabytes. It can take as much in an email as you're going to fit onto a CD. USBs are slightly different. I know there's some people who do occasionally use USBs for a certain purpose, sometimes backing up your HR system or your Sage, your payroll system. But what I'd say, you should be using the encrypted one, so we can easily give you the encrypted USBs if you need them. But you can't trust our network. It does. It will work for that as well. GP to GP, yeah, for GB transfers, GP to GP should work. If it doesn't work, report the issue, but don't be sending stuff on CDs. Okay, and that's me done. Thank you all for listening this morning. I hope you found that interesting. Let's just come off that and I'll stop sharing. Does anyone have any questions off the top of the head? I should have a look at the conversation and see if there's anything in there. Oh, there is. Let's have a look. It's loads of questions. Right. Let's see. I think I've got the suns on my screen. I can't read it. Yeah, Sally, good idea. A good point. I'm not sure how asking for identity can be discriminatory if you ask everybody. So if you're going to have a system in place, remember the onus is on you. And I presume this relates, I can't quite see where this is. I presume this relates to the registration issue. So when you're registering a patient, the onus is on you. And I can't quite think how it's worded, but it's something like I was saying, really, if you want to say you're a staff, the onus on you is to be absolutely certain who you're talking to, that the person who's come up and says, I'm Mr. Smith, I've just moved into the area, I used to live up in Burnley and I'm now living at 3 Acacia Avenue. How do you know that? How do you know? So you look up on Mr. Smith and there are no doubt many Mr. Smiths, and many of them will have the same date of birth, and there are probably even quite a few who used to live in Burnley. How can you be certain that that one is the one that you're going to register as your patient? I don't think it can be discriminatory to ask him for something to demonstrate. I mean, as we said, more people will have the NHS app these days, which is great because that's got your NHS number on there. I mean, that's the NHS number is the absolute key. Across healthcare, we identify people not by their names because we know there are so many people with the same names, but we use the NHS number, which is a unique identifier. And that's the key one. If anyone has got that, that's perfect. That's the one thing that you need. So if they've got an old prescription, as I say, if they've got the NHS app or something along those lines, then that's perfect. Photographic ID will help you obviously in terms of who they are, but I don't think it's being discriminatory. You're absolutely right. It's a balance. It's a balance between knowing who the person is and you know, some people, you may not need anything at all. Some people, yeah, I know, someone can vouch for them. I know, yeah, this chap just moved in next to me last week, or perhaps one of the members of staff knows who they are, something along those lines. Not obligatory. I think the requirement on you could say that. I've seen many practices when I've been researching this who do have it as a requirement that they produce a formal identification, and I don't think they've been criticised. I think that is your legal responsibility. I mean, there are always lots of different legal responsibilities here, aren't they? Yes, you have to be. You're not allowed to discriminate. That's absolutely the case. However, you could ask people, asking to see some form of identification isn't being discriminatory, I don't think. I think it's fulfilling your legal obligation to keep accurate records in accordance with the Data Protection Act. Okay. Yeah, around COVID, in terms of giving out vaccinations and so on, you've got to be clear on the name, spellings. It is a difficult query. Janet, absolutely. In terms of third-party information and information that other people have added that you then give out as part of a subject access request, that's always going to be a difficult issue. You to some extent, you are responsible for the whole record as you hold it, albeit that you may have, in some cases, you may have only recently come upon the record. So we've got a case, I know, at one of the practices where a patient moved into their new practice, asked to see their record literally after only a few days after they'd moved in and got registered, and there was a huge issue with that with the data in there, and we're having to go back to the previous practice because although they're the current data custodian for the record, the patient's only just come from somewhere else, and it's somewhere else where the issue has been caused. So we can go back to other people and to other agencies, but ultimately you are responsible for that record that you've got in front of you. Yeah, Tony, that's a classic point around having to review the records before making them available online, and that is a point that a number of practices have made. It is difficult, and I'm not sure there's an easy way around it. If you're going to give people, I mean, you can do the bit. Okay, we'll give you access from now forward, and there's a name for it as well, and that meets the requirement for probably for most people actually to say, okay, we'll switch it on from now and looking forward, because and it's reasonable. Certainly, I mean, absolutely now, as we are general practice being so busy and incredibly, all the pressures you've got, to me, that's absolutely reasonable. It meets the requirement. It lets people have access, and they can see their record going forward from today. You simply don't have time to review as you say, the thousands of records looking back to do this check. Whether that will be something that will come along, whether you have a process to work through it slowly in the future, I don't know, or whether you just wait until someone does the subject access request. But not the problem, but the challenge then is, so you said you're going to give people now access from now going forward. So let's put the historic stuff behind us and say, okay, we're just not going to do that for everybody with online access unless they'd make a subject access request. But going forward, what we will do is we will check the data that comes in. So almost in real time, as you're working on the systems, if you have third-party data or that serious harm test is met, then you can mark that data. And I'm pretty sure within System 1 and EMIS, you can mark it as don't make it visible on the record going forward. So it's not available to the patient on the online record. And I think I'm right in saying there's a tick box you can do. So if you have a section, an episode of care, whatever, that you think you don't want to make visible to the patient. And if you're then into having to do that almost in real time as you're going forward, because as we've said, we've given patients a real-time view of their record, the redaction bit, the two bits that they're not supposed to see, you're going to have to be dealing with those in real time as you go along. Sally makes a good point there. Yeah, assume that the patient will see what you've written. They don't always like it. I'm sure they don't. Views and opinions are what they are, and that's the absolute key bit. I think that's what many patients do want to see. They want to know the views and opinions that are being put on there by medical professionals, because that's that's the job that you guys have. Third-party information. It's a very difficult one. I'm going to try and do some, because I'm not sure I've quite got this enough of a grip on the third-party information, and we need to get some real-time examples. I need to put together a whole package to help you to say, right, this is exactly what it is. Is this, is the mother-in-law's name a third-party information? Is all these types of things. So that's the very specific piece of work that I'm going to be doing, because I think it's not entirely clear. I had a case. It was, I'm not going to name names. It was a practice manager. We were having this discussion the other day about a patient who he's an elderly-ish patient, been married for a long time, and had, I think, one of his daughters was possibly carer. But essentially, they'd asked for his information or a subject access request, but all through virtually every bit of his record, there was mention of family members, because they were involved in his care, they were involved in looking after him. And essentially, the practice manager was saying, if I take out this bit, this third-party information that doesn't relate to him, that relates to family and friends, there'll be basically nothing left in the record, because it's so entirely involved. So that's a question that we have to look at. Yeah, and I take the point here. How do you know what it is and what the implications for revealing information? So that's interesting. I think for most cases, and if we think of that one, the case just mentioned, there wouldn't be any implications, because the individual knows that these people were involved in their care. It's people that he knows, and he would expect that information to be in his record. The sort of thing, and whether this is a ridiculous example, but it's the one that I remember being told years ago, would be a case where perhaps a district nurse goes to see an elderly person in their home, and as they leave, as they've seen the patient says, "Yeah, I've been feeling much better, thank you." And patients often kind of, I suppose, some don't. Some say they're a lot worse than they are, and some are right, and moan about stuff. But others do sometimes say, "Yeah, I'm better than I am." And then, as the district nurse leaves, the next door neighbour says, "Did Mrs. Smith tell you how poorly she was the other day, and that she had this, and this?" And that's kind of third-party information coming into a record that the patient doesn't know about. It's someone else putting information in. And I think that would be fairly clear, that you'd be able to take out that individual's name. And the other one you tend to get when you have things around safeguarding, which is a whole different kind of worms, but where you have allegations from sometimes members of the family around things that have happened. So that becomes very, very difficult. But this is something we do need to get our heads around this, or certainly I do, and I need to be able to give you some better information, I think, than we are at the moment. Yeah, Anita, giving people that online access and then it causes problems because they make complaints about the written note. I think that links back to the point earlier on, that people don't always like what they're told. They don't like, sometimes, the truth hurts. That's a stupid expression, sorry. The reality of what a professional thinks of them can sometimes not match with their perception. Is that a better way of putting it? I'm trying to put it nicely.
We sometimes get people then coming back to us saying, well, why did you take that medication off, and why did you swap that medication? And they're actually questioning the clinician's decisions.
Yeah.
And then they start to go and put complaints on you, which has caused a lot of problems.
Yeah, no, I can see that. It is difficult. I don't know an easy answer to that one. I think, in principle, individuals have the right to be able to see their records. We have to accept that. That's not just a principle of healthcare, NHS. That's the law, that you've got the right to see all this information. It will, on its own, therefore, people will disagree, and I suspect there's more of a society thing, people disagreeing with professionals. It's driven by this thing that we no longer believe experts anymore. So people are more likely to question, and I think that's, as I say, that's a more modern society thing that will have increased, and I suspect, unfortunately, from many cases, will continue to increase. People will have the right to see this. They will become more questioning. They will want to. I mean, the next thing, they will want to put in their own information. So there isn't an easy answer. I suspect, complaints and so on should be straightforward to withhold. The healthcare professional makes the clinical judgment based on their professional judgment at the time, on their experience and knowledge and so on. And the patient might not like it, and to some extent they can challenge it, but that's not a complaint. That's the individual doing their job. And I think you do need to move to a point, which I think someone was mentioned on there, that when you're making a record, always make it with the assumption that the patient will read it. The patient will, at some point, either immediately or at some point in the future, will read that. And that's right. You should be telling them as well. So you should only be recording information that you've probably told the patient or that they're aware of. And that you can, if it's something that they don't agree with, then that's the opportunity to record in there that, I told the patient this, I said this is what my professional view is. The patient didn't agree, but at least they've had that already up front, so they're not going to be surprised. And that is another concept in data protection, that the patient shouldn't be surprised about what they hear. So even when they get their medical record, they shouldn't be, wow, I couldn't believe the doctor wrote that about me. I'm absolutely amazed that wasn't like the conversation we had at all. They should never get to that point. A couple of points about the police here. Yeah, Paula, that's correct. Yeah, the police don't make a subject access request. They don't ask for the full record. Very, very rarely, I suspect, would they want the full record. They make a case to you, and there's a very specific process by which they do this. And yeah, someone said they could be a bit scattergun. I suspect that's the case, but they to some extent that they're not the enemy in this, and I hold my hand up here and speak as a former police officer, that they have a job to do as well, and I think that a level of cooperation and that should go here. But you're right, but also you're the custodians of the record, and you're absolutely clear on what they can and can't see. They need to make the case to you why they want it and what information it is that they're seeking. And I'd suggest the best thing to have is a discussion to say, well, you then know the record, and you can say, well, we can, this bit might be helpful. So rather than them just coming to you saying, can I have this, and this? I think if they come to you, and if you're able to engage in a dialogue with them, and then have the proper documented request from them for X, Y, and Z, whatever that may be, that you're able to fulfill. But yeah, definitely only the bit that's relevant to their request. So they should be able to make a request to say, I want this, and that is all the bit that you would give them. The egress thing, Paula, I haven't really used it from the other side, so it's perhaps something I do need to do. If you send it out through the egress, they want to their normal. Doesn't it go to their normal email address and they then log in and download the data? I'll double check on that one. It should be straightforward. You're right. If essentially they don't want to use that system, so the onus is on you, as I mentioned, to get the data securely to them. If they say, I don't want to use this secure system that you've got, I want you just to send it via a normal email to me, to my normal email account. If you essentially get an email from them that says that, then fine, I would go ahead and do that. As long as you've got their documented bit that says, please send me this. I don't want to use your secure system. I want just you to send it to me in a normal email to my normal email account. That's fine. You should just go ahead and do that. Will the slides be circulated? Even better than that, Julie, we'll put the whole recording of it online. So yes, I'll put the slides on, but also it's been recorded, so I'll put that online. It'll be on the IG web portal that we've got. Egress, there's a specific fact sheet on egress. I don't know if I actually called it that. Let me have a quick look and see. Let me just have a look, because I did a fact sheet that talked about it, and it's just you can open it up yourself, and just run it, or if you just put a service desk call in, the guys will log on your machine and run it for you. I'm just trying to have a look and see. Fact sheet number 15 talks about NHS mail security. Yeah, and that's the one. Yeah, it's that one there. So if you go on the web portal, Daryl, fact sheet 15 is the NHS mail security one. It talks about egress on there. There's a couple of links. But as I say, if you're stuck with it, just drop a service desk call in, and the guys will be able to log on your call onto it. And it's like it works as like a bolt on to your Outlook program, and it gives you the ability to do the big email files, but also you get all the receipts and stuff like that back if you're doing it to a non-NHS address. When you go back to the patient record, do you go from the beginning? Yeah, you can do either. Is the answer to that, Daryl? You can do from the start, if you've had the opportunity to look back and do the review of the historical record and you're happy that there's no data to redact if you've got time. But I know that's one of the problems that people are raising. The other one is to do it from today forward, and there's a system to do that. I think, well, I know System 1 does it. I'm sure EMIS does the same, that you can just say, okay, you've got access from today going forward. Make it available from consultation documents. Paul, I'm not sure where that date came in. I think there is a date in terms of the NHS contract, that your GP contract, that says you have to make information available, or you have to give people online access. So that was presumably when the new contract came in that says you have to be able to put this in place. But it doesn't mean that that's the date when you have to set it to. So I think if a patient comes in today, you can say to them, we can give you online access from today forward. And remember, the majority of patients are going to be wanting your repeat prescriptions and the appointments element of the online record, but not many of them are really wanting the record itself. But you just say from today forward, and that's how you set it up. There is a specific bit around this. I'll circulate this later on, actually. Yeah, what I would say, Anita, don't change stuff at the minute. You put yours, remove the carers' names, etc. Should we leave them in? Well, let me just have a think on that one. No, I think people who are doing their job in relation to the patient, they should be named. Should be named. That's not right. You can leave their names in. They can be identified in a record. So essentially, your staff, the doctor they see, the nurse they see, if there are reception staff involved in care, if they see, so basically anyone who does their job, and if you're involved in recording stuff from others, so carers and so on, if it's the name of the ambulance crew or anything like that, anyone who's doing their job in relation to the patient, their names can be left in there. Essentially, they are a part of the record. They're part of the history, part of the medical record of that patient, that an individual, whether it be a carer or a doctor or a nurse, did certain actions to them, and that's part of the record. So yeah, you can leave that in.
Okay, thank you.
Okay. Yeah, mental health issues, it is very difficult. I have a friend who works in one of the larger mental health trusts around Leeds, and I must admit, I go to him. As some of you will know, when you've asked me issues around mental health questions, I defer to him, because if you're dealing with it all the time, you know the ins and outs, and patients who have mental health issues can be some of the most challenging patients that you're going to get. It is also generally where that serious harm test would come in, but again, it's only at the very, very serious end of mental health issues, where you withhold, essentially probably where you're withholding information from the patient, and legally you can do that, but again, there's an awful lot of safeguards to that. But yeah, they are going to be difficult issues, and I would suspect if you have issues around mental health queries, I mean, certainly come to me and I can go to my friend who's able to help me with that, but also go back to in mental health, go back to the person who's written it. So if you have a letter on someone's record and you're not sure, go back to the person or the organization that brought the letter, or that sent it to you, the authors of it, and ask them for their advice. They can't tell you what to do. You can't be told. If someone sent you something, they can't say, no, I don't want you to do that, or you're not allowed to do that. You still have to make the decision, but certainly I'd engage with them and get their thoughts and advice on that before you release the record. Let's see what else we've got here. Just looking through. Okay, yeah, appreciate many of you have got to go now. I've run way over the time that I said. God, it's almost 10 o'clock. Wow. Thanks very much for sticking with us, those of you who have. I think we've covered off all the questions. Did anyone want to ask anything else just while I'm still here? Okay. I will put the whole recording of this online on our web portal. And there's a couple of other little actions you've got from me as well, which I'll get, and hopefully I'll get all onto the web portal later today. If you've got anything at all you want to drop me a line about, please feel free. Just barry.jackson@nhs.net, put it through the service desk, whatever it may be. But yeah, just get in contact with us. Anything at all that you want to ask about anything we've covered this morning. Okay, we'll call that a morning then. Thank you very much, everyone. Thanks very much.